Hello friends, welcome to our YouTube channel Indus Lex Magnus Associates. Dear friends, today we are going to discuss the nuances relating to laws of passport. Dear friends, whenever any criminal case is pending against your name or in the name of your relatives, then the local police will give the adverse report to the passport authority that you have a criminal case against your name. And in this scenario, the passport authority will not proceed with your passport application, whether it is for issuance of the passport or at the renewal stage. Then what remedy you have? Dear friends, Article 14 of the Indian Constitution, read with Article 21, give you right to move freely anywhere in the world permitted by law. And there is pendency of criminal case is not an ground to not issue or renew the passport. But for the check and balance, you have to follow the procedure. And what the procedure is? Dear friends, if FIR is registered against your name, or in pursuant to that FIR, a criminal trial is proceeding in particular court, then from that court you have to obtain non-objection certificate. And it is highly probable that court will deny your application of obtaining non-objection certificate. In this scenario, you have to move High Court under section 482 CRPC. And if NCR is registered against your name and there is no order of investigation by concerned competent magistrate on that NCR to investigate the case, courts direct to the DGP that he should direct their employees, their policemen, that not to send adverse report regarding those NCR in which investigation is not ordered by the magistrate, or also in those FIR which is time barred. And in this scenario, Allahabad High Court passed an order in Basu Yadav versus Union of India and reiterate that if FIR is registered against any person, then he has to comply with the government order dated 25/8/1993, in according to which you have to obtain non-objection certificate from the concerned court. And if that concerned court dismiss your application, then further you come before Honorable High Court under section 482 CRPC for that non-objection certificate. And if NCR is lodged against you and no order of investigation is passed by any competent magistrate, or that 3 years has been passed after the registration of that FIR, that NCR, and you have, after that you have going to apply for your passport or for the renewal, then you may approach Honorable High Court directly for the issuance of the passport. Another, a very sharing example is that if you already possess the passport and residing in foreign land, and at that time you feel that you have to get renewed your passport, and you applied for the renewal, and in the meantime when you are in India at the holiday, some person may file 156(3) application, and on that application FIR is registered against several persons, in which one of the member is you. Against you the FIR is registered in the meantime when you are on the foreign land. Then you may directly approach to the Honorable High Court for the issuance of your passport. So it is reiterated and it is completely expressly laid down by the Honorable Supreme Court in Wangla Kasturi versus CBI that the passport authority cannot refuse the renewal of the passport on the ground of pendency of the criminal appeal. Even though if you get free or convicted and you are on bail, and in meantime you applied for the issuance of the passport or of the renewal of the passport, and the passport authority has not right to claim that you against whom the appeal is pending in the higher court. So as a passport authority cannot are not going to issue the passport. He has no right to say it is illegal, and that is why the Supreme Court has expressly laid down the law. Dear friends, we will bring more interesting videos on the legal aspects. Kindly subscribe our channel, share it as more as you can. Thank you.